Good morning friends, Sat Sri Akal, Adab, Namaskar. This is my 170th video and it is a bungalow number 194 measuring 3.56, 3 acres, survey number 160, Agra. This originally bungalow was owned by Hamid Ali Khan on the strength of a grant under the Government of India, let's presume. A sale deed was made on 11th September 1946 in favor of Chhail Bihari Lal and his two brothers Naval Kishore and Kapoor Chand. The bungalow in question had been originally rented to the emirs way back in 1942 on a monthly rent of 125. The purchaser knew about this and he purchased along with the statement that he will be entitled to drive out the rent from now onwards. So the new owner filed some continuous suit for rent. He filed a suit in 1958. He recovery of areas of rent and damages and for vacant possession of the suit property. So again a second suit was filed by Naval Kishore, one of the pedigree owner. Suit number 6 of 1963, again the same story, but it in a appeal preferred by the Union of India was however allowed, holding that there was no valid contract between the parties. Now here there is an appeal which is approved on this suit of 1963 that there is no written document in between. There is so surprising doings. Again a similar suit to recover rent was filed by Naval Kishore Sharma in 1968 now. The earlier one was null and void and the appeal, and for various reasons the third one has been filed now for another amount now. This suit was decreed in 19. Now this suit gets decreed in favor of Naval Kishore, but to an extent of a recovery of some 8,000-9,000 rupees only. The trial court did not go into the question of title to the property in the suit based in tenancy and finally said, okay, the Union of India is for. It is very interesting that in the first suit filed in 19, the court does not find anything on record to see that resumption notice was issued. 1958. The appeal came up, the second judge, the said judgment in the degree. While in appeal in 294 of 1969, which was filed by Naval Kishore, and other appeal of number 66 of 1970 was filed by Union of India. So these were two appeals filed for the 1968 order. Both these appeals were heard together by the department, by the my lord, and it was finally allowed that Mr. Naval Kishore Sharma should be given his rent. The High Court held that although no contractual tenancy came into existence between the parties, a statutory tenancy came into existence. Provisions were given under the House Accommodation Act. And because it was an House Accommodation Act lease, so under the Article 299(1), a contract where the Government of India is entitled, the applicability of the tenancy is not to be proved. The statement of finding of the High Court must either come from a pleading or from the parties. This is what I am trying to say. So whether anywhere did Naval Kishore or the predecessors pleaded House Accommodation Act, or did the department come up that this premises was taken under? This is where this bungalow needs to dig into its papers. Somebody who speaks of House Accommodation Act, only then it comes. The High Court also found the composite notice served under Section 80C, fine, Section 106 of the 6 of the TPA Act, all valid. So meaning that TPA Act is applicable in cantonments. This is being upheld. High Court even found that yes, this all doing speaks of restrictions and under the Grant Act, Crown Act, which we call, where under Section 3 it says TP Act is not applicable, and maximum judgments which have been coming in the past are only on these bases. So High Court, this judgment for this part sounds good. What is the High Court doing? It is declaring the suit for recovery of possession by ejectment of defendants from the bungalow and the land. Now High Court here has even ejected and even stated that underlying the same with the direction to remove the barracks that were constructed on the part of the compound, failing which the same were directed to be removed by the orders of the court and the possession delivered to the degree holder. So there is something missing in between, that this bungalow owner on an execution from the High Court had even filed an execution of a degree. So this civil second appeal 1935 of 1970 and 1936 of 1970 filed by Union of India against the said order, dismissed by the order dated 8th February 1984, passed by the High Court, as abated on account on failure of bringing in the legal heirs of Naval Kishore or the original owner. Now, friends, we must listen. In most of the cases, if you see my case, Union of India is a RSA. My father died, one of the owner was there, Union of India did not bring in the LRs of SSRs. But when it comes to compensation, they want the LRs of SSRs to be there. But when they want to fight the suit in RSA, which was their suit, they don't. Even in Chitra Kumari, no LRs were brought till the Supreme Court. She died during the pendency of the High Court case. These are some cases which are on my tips because from Ambala. So what does a plaintiff do? We need to, wake up and see all these small nitty-gritties can be pleaded and courts can interpret them for us. So the legal heirs, they filed an execution degree on the High Court order number 16 in 1977. Now this degree went to court. Now what happens when Union of India is made to face it? The Union of India clearly challenges this execution of degree on the ground that the bungalow has already been resumed. Just imagine. Matlab 1977, the execution of a degree is being held by the High Court and the owner is filing one. And in the execution, the department comes up and tells the owner or the court that the bungalow has already been resumed. What are they upholding? That part bungalow, the total bungalow was 3.563 and 2.792 of the bungalow has been resumed. By an order dated 24th September 1970, the Union of India resumed the affirmation and 0.771 acres of land was lying with the main bungalow of the owner, for which a resumption notice was issued in 1976, February. This is what he is saying. Where are these papers? And partly the bungalow is being resumed, meaning that when the first case was filed in 1958, there was no resumption notice. 1976, the government or Union of India does not realize that their bungalow has already been resumed in partial resumption. Possession has already been taken. So what is really happening? Nobody really knows. And the same notice was challenged on the grounds in High Court. Resumption order, the grant filed in a writ petition of 1482 of 1971. It was allowed by the division bench of the Allahabad High Court. What were the findings? That is very important here. Holding that the Government of India could not take over, resume any building or land except or serving 1 month notice or paying to the owner compensation of the property being resumed based on process or determination with which the erstwhile grantee is also associated. The High Court held that since no such notice was served nor any compensation determined, the resumption order was unsustainable. Notice is being quashed. This is the first notice given to Naval Kishore, but here the court states that the second notice 23rd September 1970, purporting to the resumption of 2.79 2 acres of land, was never challenged by them. So which part was challenged? 0.771 acres was challenged. Actually, the other part was never challenged by Naval Kishore, because that was in the open land area, where after resumption the army created their barracks also. I don't know whether these people are alive in Agra, whether they are in possession of this bungalow, but this case came to me and I wanted people to hear about this case. There are such people also who live in a lethargy situation. They do not challenge their resumption notice because it is of the open area. We have a case in Ambala where Kanwar Chand went up till Supreme Court for resumption of his outer area. His main bungalow is left, like this case. Similar, but he challenged. He didn't let it go like that. Here the bungalow owner gave it in 76 and he kept challenging only 0.711 acre. Union of India has claimed that possession of the said area has already been taken by competent authority on 6th November 1970. After exactly 1 month, they even take the possession. The Union of India therefore argued that this resumption of land in question had attained finality, and since possession of the same has been taken over the degree holder, there was no question of dispossessing the Union of India from the said extent of land in execution of the degree passed in favour of the petitioner. The civil judge rejected the objection raised by the government. The justice judge in revision affirmed that the order holding that the objections filed by the Union of India were time barred. So again the Union of India loses. The Union of India did not accept the orders in execution, moved to High Court. Petition number 43928 of 2002 before the High Court. It framed three major issues. Whether the land in dispute is an old grant and resumption of part of the old grant on the land measuring 2.729 acres. Notice of 23rd September 1970, of which possession was taken on 6/11/1970, has been final between the parties. What a funny thing. Answer is affirmative, obviously. Part bungalow has been gone. 1970 resumption notice is there. The second law point was whether the issue regarding the land being old grant land was directly substantially in issue between the parties. Suit number 842 of 1958, and cannot be re-agitated, and it will be worked as a principle of educata. So here also the court says it does not, the principle of residucata did not therefore debar the plea of the grant was an old grant. So that means on old grant there is no residucata. Funny. This is something which I need to interpret in law. The third point was under section 47 CPC, the petitioner execution was barred by limitation. The question here is that there is no limitation to file an execution degree. It's in section under CPC 47. So though the whole question was that the HOR, Naval Kishore, never challenged the resumption notice. And his execution degree was speaking for 0.771 acre. And it is very interesting, the court orders the entire degree for 3.523 acres. Here there is a finding given in the court. It is not a question of an old grant or a new grant. Now, where is this finding or this mindset coming? Was it in any of the arguments in front of the courts? Whether it was a written statement needs to be verified. The owner is trying to bring it to old grant and new grants, but he doesn't know what is old grant and new grant. So very interesting, the Union of India never questioned the degree to the main bungalow, and the possession was already handed over to the HOR, legal heirs Naval Kishore, and we do not want the same. As a matter of fact, possession of the main bungalow have been delivered to the degree holder, entitled to retain it till such time Union of India issues any further orders in resumption. So the whole case went from 3.563 acres to a part resumption of 2.72 and 0.771 acres. So Naval Kishore Sharma order of execution application number 16 of 1977 was upheld partially. Main points which were raised in this case were House Accommodation Act, resumption notice was not challenged, arrears of rent were being paid. So was this a lease under House Accommodation Act? Whether the owner could prove his old grant or not. So these small things. Now what does section 7 of the House Accommodation Act say? Procedure of taking houses on lease. If on the report of such person, officer commanding is satisfied that the house is suitable for occupation of military officer or a military mess, he may require a notice, execute a lease, vacate existing if any to vacate the house, require within such and so there are about B3 points. What does the Constitution 299? All contracts made in the exercise of executive powers of union or the state shall be expressed made by the president. That is also fine. But here, this entire case which flows to the Supreme Court, it is vicious. You are already upheld by partial resumption. You come up for the balance rent and you don't even know that in 1970 your bungalow has gone, the open area has gone. That is the travesty, friends. Please, let's all wake up. Let's all get up. And why am I coming with this series of judgments? So that you people understand this is a case in Agra. This case will affect people in Agra. Is the bungalow owner yet in possession? Please, I would request Agra people to find out, get him on board. There are some amazing point of 0.771 acres which has been de-hired to him. Partial resumption has been done. If anybody in the inheritance of Naval Kishore or Kapoor Chand are alive, please ask them to get in touch so that we can move forward and do something good about this case. Thank you. Good day.